We are a peaceful people. Struggle is with struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, daytime or night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We are a peaceful people. Struggle is with struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, daytime or night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one can rise, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We are a peaceful people, struggle is we struggle, and we don't look for trouble, just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain.
Honorable members, Mr. Speaker.
Honorable members, I declare this 90th sitting of the National Assembly of the 12th Parliament of the Cooperative Republic of Guyana to be duly constituted and in session. The clerk will lead us in prayers.
Almighty God, we who are gathered together do most humbly beseech Thee to guide us in all our consultations, so that we may together build a land where knowledge is free, where the mind is without fear, and the head is held high, and where words come from the depth of truth. Grant us, O God, the needed guidance, so that we may deal justly with the several causes that come before us, laying aside all private interests, prejudices, and personal preferences, so that the result of our counsels may be to the glory of Thy blessed name, the maintenance of true religion, the preservation of justice, the safety, honor, and happiness of the President, and the peace and prosperity of Guyana. Grant us, O God, the vision so to lead, that all the people of this fair land may enter into that state of brotherhood and unity, where the mind is led forward by Thee into ever-widening thought and action.
Please be seated.
Messages from the President. Announcements by the Speaker.
Honorable members, please first let's stand in a few moments of silence to recognize the unfortunate death of a member of the Trinidad Parliament, the late MP Lisa Morris Julian and her children. And we also want to pay reverence to the passing of Tushau Ridley Joseph of Tasserini and those who lost their lives going to St. Cuthbert earlier this month, and those who have passed away as we approach this particular festive season. And the speaker is saying to me, a former member of Parliament, Marshall, who served many, many years ago. Thank you. I will ask the clerk to send to Speaker Bridget Anaset George our condolences on the passing of the Member of Parliament from Trinidad and Tobago. While we have had some sad moments recently, we have in this December several members who celebrated birthdays since we last met to now. And I think as early as yesterday, we had many members. I'm just trying to get my notes together here. To recognize those persons, we have the Honorable Members Amanza Walton Desir, the Honorable Member Sherwin Holder, the Honorable Member Vincent Roy Jordan, and Opposition Chief Whip Christopher Jones. The celebration bill is on him. Thank you very much. Mr. Clerk.
Presentation of petitions, presentation of papers and reports, etc.
The Honorable Senior Minister in the Office of the President with responsibility for finance and the public service.
Thank you very much, Mr. Speaker. I rise, sir, to present to this honorable House the following orders. 1, the ministers, members of the National Assembly and special officers' emoluments. Order 2024, order number 85 of 2024. And 2, the constitutional officers' remuneration of holders. Order 2024, order number 86 of 2024. Thank you very much, Mr. Speaker.
Thank you, Honorable Minister. Honorable Minister of Human Services and Social Security.
Thank you, Mr. Speaker. Mr. Speaker, I present to the Assembly the third special report of the Parliamentary Sectoral Committee on Social Services on the visit to the Sophia Care Center, the Children and Family Center, and the Palms Geriatric Institution on Wednesday, 15th of May, 2024, and this effectively concludes the entire work program of this committee under my tenure. Thank you.
Thank you very much, Minister, and congratulations on completing your work program during your tenure. Mr. Clerk.
Oral questions without notice.
Honorable members, there is only one question on today's order paper, and it is for written reply. That question is in the name of the honorable member, Mr. Richard Sinclair. Sorry, Richard Sinclair, and it's for the Honorable Minister of Education. The Honorable Minister has asked for some time to provide that written answer. Honorable members, I did receive a note from a question from the Honorable Member, Dr. Karen Cummings, on the oral questions without notice. The questions she posed, they do not meet the requirement of urgent, and we're asking her to provide those questions for written replies, which will be sent on to the relevant minister. Mr. Clerk.
Statements by ministers, including policy statements, personal explanations, request for leave to move the adjournment of the National Assembly on definite matters of urgent public importance. Motions relating to the business or sittings of the National Assembly and moved by a minister. Introduction of bills.
Honorable Minister of Public Works.
Thank you very much, Mr. Speaker. Mr. Speaker, I present to the Assembly Engineers Bill 2024, Bill number 21 of 2024. A bill into an act to provide for the registration and regulation of persons in the practice of engineering in Guyana and for related matters. And I move that the bill be read the first time.
Let the bill be read the first time.
Engineers Bill 2024, Bill number 21 of 2024.
Honorable Senior Minister in the Office of the President with responsibility for Finance and the Public Service, Dr. Ashni Singh.
Thank you very much, Mr. Speaker. I rise, sir, to present to this honorable House the Financial Institutions Amendment Bill 2024, Bill number 22 of 2024, a bill intituled an Act to amend the Financial Institutions Act. And I now move that the bill be read the first time. Thank you very much.
Thank you, Minister. Let the bill be read the first time.
Financial Institutions Amendment Bill 2024, Bill number 22 of 2024.
Honorable Minister of Culture, Youth and Sport.
Thank you very much, Mr. Speaker. Mr. Speaker, I present to the Assembly the Guyana Horse Racing Authority Bill 2024, Bill number 23 of 2024, a bill entitled An Act to Provide for the Regulation of the Horse Racing Industry to establish a horse racing authority and for connected matters. And I move that the bill be read the first time.
Let the bill be read the first time.
Guyana Horse Racing Authority Bill 2024, Bill number 23 of 2024. Public business, government's business.
Honorable members, we will now proceed with the second reading of the Acquisition of Lands for Public Purposes Amendment Bill 2024, Bill number 16 of 2024, published on the 22nd of November 2024. Honorable Attorney General and Minister of Legal Affairs.
Thank you very much, Mr. Speaker. I rise to move that the Acquisition of Lands for Public Purposes Amendment Bill 2024, Bill number 16 of 2024, published on the 22nd of November 2024, be read now for a second time. Mr. Speaker, this bill has unfortunately excited a lot of public attention, where a huge deluge of misinformation and distortion have been peddled about it in the public domain. And as a result, I feel compelled to elaborate for the listening public how those distortions are inaccurate, and to allay whatever fears may have been excited in the public domain by those distortions. Mr. Speaker, I want to also put on the public record that last week I received a letter from the Honorable Christopher Jones, in his capacity as Chief Whip, requesting a meeting to discuss these very amendments. I responded Tuesday to that request, accepting the offer to meet. I indicated in that acceptance letter that the Honorable Gail Teixeira will attend the meeting with me. A time and a place was fixed for the meeting as indicated in the letter. The meeting took place at the scheduled time and place, that is to say, 3 o'clock yesterday afternoon in the boardroom of the Attorney General Chambers. And at that meeting, Mr. Roysdale Ford, Mr. Ganesh Mahipal, Mr. Sherrod Duncan, Ms. Annette Ferguson, and Mr. Vincent Henry were in attendance. It was at the conclusion of the meeting, it was agreed that certain amendments would be made to one clause of the bill, that is, Clause 3 of the bill, which seeks to amend Section 24. The meeting concluded in a very harmonious atmosphere and with the common understanding that the parties were at idem on what those amendments should be. One amendment or amendments to one clause of the bill. It was also decided that I should send a draft of that amendment earliest to Mr. Ford so that it can be examined, I suppose, to ensure that it met the expectations as discussed. The meeting concluded just after 4 p.m. and at 5:30 p.m., 5:29 p.m. to be exact, I sent an email to Mr. Ford with the proposed amendments as discussed. I did not receive any response from Mr. Ford to my email, and I sent it to two separate email address, roysdaleford@gmail.com, and I think Roysdale Alton Ford at some other address. I didn't receive any response. I assume, therefore, that there was no other objections, and I proceeded to submit to the Office of the Parliament early this morning the amendments as per our discussions. I outlay that, sir, for the record, because unfortunately, I am hearing that there are still some disagreements in relation to the amendments. The meeting was, as I said, intended to address all the concerns. There were no prohibition against issues being raised. I consider it to be a thorough discussion. It was also conducted in a very good atmosphere, very cohesive atmosphere, and thereafter I concluded that we would have addressed all matters of contention. Unfortunately, and yes, in fact, Madam Gail Teixeira and Mr. Mahipal took the occasion of speaking about meeting more often to get that kind of harmony and unity in our thoughts and work. As I said, unfortunately, I am hearing something differently. But in the course of my presentation, sir, I will address what the bill originally said and what the amendments are as per our discussions. But as I said, there is a larger question of dealing with the distortions that have been peddled. So, Mr. Speaker, the impression has been conveyed in the public domain that the government is moving for the first time in this House a bill that would authorize the government to compulsorily acquire private property for public projects. That is the first notion that I wish to reject out of hand. The law of Guyana, since it was a colony in 1914, reflected a power in the state that allowed the colony at the time, under the hand of the Governor General and the Colonial Secretary, to acquire public properties across the colony of British Guyana for public good. And that act, sir, is a 1914 colonial ordinance. When we became independent in 1966, it was incorporated in our law with the necessary modifications and adaptations, and it became the principal act, the Acquisition of Lands for Public Purposes Act, Chapter 62:05. It's quite an elaborate legislation, numbering 17 pages with 29 sections. The point I want the listening public to understand, first and foremost, that this law authorizing the state to compulsorily acquire private property has been with us for 1 century. It was there under the PNC government from 1966 to 1992, and it is with us now. So there is no new power that is being given to the government, the state, or the minister in question to acquire public property. In fact, I have heard also that this act and these amendments would run counter to the Constitution, because it is said, and rightfully so, that the Constitution protects private property. So I'll read from the Constitution, and I want the viewing public to see that this is the Constitution of the Cooperative Republic of Guyana. I have done it by hard copy for my own use and convenience. The relevant section of the Constitution reads, "No property of any description shall be compulsorily taken possession of, and no interest in or right over property of any description shall be compulsorily acquired, except by or under the authority of a written law, where provisions applying to that taking of possession or acquisition is made by a written law requiring the prompt payment of adequate compensation." So the Constitution itself, that guarantees the protection to private property, authorizes the state by a written law to acquire private property once compensation is paid. Prompt compensation, adequate compensation is paid. Adequate compensation is promptly paid. That is what a law must do that authorizes the taking of that property. Now, this provision has been in our Constitution since 1966. The law that the Constitution refers to is the Acquisition of Lands for Public Purposes Act, Chapter 62:05. So these are the two laws that have been with us from independence. So there is no new power whatsoever that's being given to the Public Works Minister to take lands for a public purpose that never existed before. That power always resided with the state. The next important point that I want to make, sir, is to explain the rationale for that law, as that law is not unique to Guyana in any form or fashion. That law is part of the legal arsenal of countries across the globe in recognition of the fact that the state is in charge of the public good, and occasion may arise where, to advance the public good, it may become necessary for the state to acquire private property for the public good. Obviously, with the underlying principle that when the state does this, the state must pay prompt compensation in accordance with the statute or the constitution that protects private property. As I said, that is the legal position that obtains across the globe. And it is not, as I said, a new power, and it exists under the doctrine of eminent domain. And the principle of eminent domain is this: title for any territory within a state resides with the state itself. That's the fundamental principle. It is that principle that allows the state to come to you, the private citizen, to say, look, you own this property by transport, but there are minerals beneath the surface of the land that belongs to the state. And the state has residuary ownership over those minerals and mineral rights. That is one incident of eminent domain. The state, therefore, has that residuary power to resort to its original title to take that mineral from you as a private owner of property. Another incident of eminent domain is where the state needs the property for which you hold a title for the public good. Again, in exercising that eminent dominion, eminent means superior, dominion means control, possession. The state never loses that. You need that. And your title, my transport, your certificate of title are all owned by you, subject to that overarching power of an eminent domain which lies in the state to take that transport or title from you and pay you adequate compensation once it is for the public good. Obviously, you now have to have a law that sets out the process, the procedure that must be followed, and the principles upon which compensation is computed, so that the law doesn't run afoul with the constitutional protection accorded to private property owners. And that is why in every country there's a separate law that contains that procedure, contains that principle, and has provisions that will permit the computation to arrive at value. So firstly, the minister can wake up one morning and determine that he will use this for the public good. The public good and the public project has a definition. So when you decide to embark on a project and you want to take public property, it must satisfy the definition of what a public project is. It must be a project of the kind that will benefit the citizenry or a large section of the citizenry. Secondly, there is a procedure that is outlined on how the process must unfold. The people must be notified, surveyor must go, demarcate on a plan the precise area to be acquired, and then the question of compensation has to be addressed because you're dealing with people's private property. Now, let me put on the public record also that in 1975, there was an amendment done to our law, this very act, that pegged compensation not at market value, but at a 1939, 31st of March value. And the government of the day, in 1979 to 1992, when it was changed, 1991 when it was changed, acquired a number of private properties, but instead of paying market value, they paid a 1939 value. So you were acquiring property in 1976, in 1977, 1988, all the way to 1990, but you are not paying market value, you are paying a 1939 value. And there are many cases that went to the court that demonstrated, and I can quote them if you wish. Comrade Ramjatan would know them, the Honorable Roysdale Ford, Honorable Comrade Ramjatan, and the Honorable Roysdale Ford would know them. That many of the properties were acquired allegedly for a national interest or for a public good, but never used for that purpose. And persons, after the change of government, after the wind of democracy would have permeated the land, went to court from 92 to up to 2000, up to now. And they have been getting back their properties because they were able to show to the court that compensation was not paid at all, because in many cases compensation was not paid, or that the compensation that was paid was not in accordance with market value. It was paid in accordance with a 1939 value. And worse yet, that the properties that were acquired were never used for the purpose for which they were acquired. Let me give you 2 or 3 examples quickly. The building that used to be Saijan Plaza, that was owned by the Singh family. They had a grocery there and a bar upstairs. Camp and Charlotte, that property was acquired for peppercorn consideration, never used for the public purpose. They opened a departmental store selling Guyanese product in US dollars in order to raise foreign exchange. Saijan Plaza. That was not a national project. That was not the purpose for which it was acquired. The Singh family in 2009 instituted proceedings 30 years after, went all the way to the CCJ, and our government had to end up paying millions and millions of dollars in compensation for that property. That's one. The house of Jainarayan Singh Sr. on Lamaha Street, the house that used to be Jung Bahadur Singh House, was acquired. They said that they would put a national archive there, that it was a historic building. It was never used for the archival purpose. I, as attorney at law, represented the family and got an order restoring the property back to the family. There are dozens of poor people in West Rumvelt, right by that school, Success Primary School there. That primary school. Not Success, the primary school in West Rumvelt. A whole set of properties were acquired. No, they were acquired. I have the record to show, because it was believed that those persons, they used to work on the waterfront, and it was believed, part of it extended to Stevie housing scheme, and it was believed that they were members of the WPA, and the then administration took all those properties, but kept the people in it to hold it like swords of Damocles over their head. The state took those properties. A lawyer named Burjett Corbin filed an application And when I was Attorney General, I took it to our cabinet and I explained to the cabinet, this is what happened. Because I wanted back the property. And the PPP cabinet made a decision that I must go to court and consent for all those people to get back their properties. And I can go on to talk about Tacuba Lodge. I can go on to talk about Hermanston, not Hermanston, the apartment place. Achillebar Villas. I can speak about Hope Estate. All of those were private property acquired with peppercorn compensation. It was being used as a political weapon in this country. Once you raise your voice against the government, this was an act that used to be used, and you used to be paid a 1975, a 1939, 31st of March valuation. Weapon against people. So when we want to go down the historical road, we must understand the history of these matters. You see, Honorable Member Amanza Desir is not here. She will come here to spew the misleading rhetoric, but she's not here to be educated and learn about the history. So, Mr. Speaker, I digressed into that historical foray so that I can put the public's perception into a historical perspective so that they understand. But let me be magnanimous and say that in 1990, it was the PNC government that moved an amendment to restore the position to market value from the 1975 amendment, where they pegged market value at 1939. I want to recognize that. And in 2001, we further amended the Constitution under the PPP government, where we added the word promptly to compensation and adequate to the compensation. Promptly to the payment. So when the Constitution, when payment is required to be paid, it is to be paid promptly. And compensation, whenever reference is made to it, it's adequate compensation. Now, when I listen to what is being said in the public domain by those who chose to platform the issue, it is clear as day that they did not read the Principal Act. So they read the amendments, which are only one page. Now tell me, how can you go and lecture publicly on a position where an amendment is being made to a principal law that is 18 pages, but you have not read the principal law? I am surprised because you still have, and I've been accused of being very naive. I have been accused of being very naive in life, and perhaps I am. I give my fellow human beings the benefit of the doubt, but I have been so roughed up with my naivety. Because when I listened, and there was a lawyer there, and I will tell you what the court, Mr. Honorable Member Royce Ilford was in court yesterday when we were dealing with these Harbour Bridge matters. You know what he told the judge? He wants the judge to take into account some person's property in close proximity. He wants me to disclose what is that person's compensation, because his property is close by. And Comrade Ramjatan is asking why. The reason why it is irrelevant is because my suit is a different quality and price from your suit.
Vastly different.
And therefore, it will not value the same thing.
Don't compare them.
You pay for value. You pay for value. If the gentleman property is a mansion, then he will be paid based upon principles of value, the market value for that item.
Let's start with the money.
And here what he told the judge. He said you must take that is the thing. That is the distortion. He said exactly that to the judge. He said, Your Honor, this property owner was of Chinese ethnicity, and his client is of Afro-Guyanese ethnicity, and therefore he wants to know what the Chinese man got. The Chinese man got a business on the roadside producing food and all kinds of things. Multi-million-dollar property, different quality whatsoever, different quality. But he asked the judge to take into account the ethnicity of the ownership, the race of the person. The judge said, hello, I have read all the law on this matter, and I can't see ethnicity and race being a factor. And the judge bid him goodbye. The judge bid him goodbye. He made that submission, and the judge basically told him to leave the court. So, Mr. Speaker, that is the kind of inflammatory, irresponsible rhetoric that is being spread. Now, you have Afro-Guyanese in that bridge project who got 80 and 90 million dollars too, because their property valued that. You have Indo-Guyanese who got $10 million too, because that was the value of their property. It had nothing to do with ethnic and color. You are a disgrace as an MP. So, look, I am
Honorable Attorney General, please withdraw
I
that.
withdraw the disgrace comment. But when you, Mr. Speaker, when you have to listen to these things, when you have to listen to the level to which they are descending in order to excite racial hostilities, it's a terrible, terrible thing. That's what I'm doing. I am simply putting on the public record what the debate is out there as a result of the misinformation that you have spread. So, Mr. Speaker, against that backdrop, I want to go to the law, the bill. So, Mr. Speaker, the bill says, Mr. Speaker, the First Amendment adds the word prompt to the word payment. So, Section 7 is being amended, and Section 7(1) that is being amended reads, and let me read it. At the expiration of 1 month from the date of the order mentioned in the last preceding section, and the date of the order is the date of the acquisition order, or any longer period fixed by the order, the land specified therein shall vest in the state. So once the order is published, the land is vested in the state. The state becomes the owner by operation of law. The state becomes owner, subject to the payment of the purchase money or on any compensation as hereinafter provided. You know what this amendment is doing, the First Amendment? Is subject to the payment, we are putting in the word subject to the prompt payment of compensation. You tell me, by what measure of interpretation can this be bad for the property owner? We are saying that when the state takes the land, the current law says you're entitled to payment. We are adding the word prompt to the word payment. So you're entitled to now prompt payment. Oh my. And prompt, I had to explain yesterday, means immediate. Immediate. You're entitled to immediate payment. Anyone can check the Oxford English Dictionary for the meaning of the word prompt. The Second Amendment, sir, goes on to say the word adequate before the word compensation. Let's go to the law. So, land shall vest in the state subject to the prompt payment of the purchase price or of any adequate compensation as hereinafter provided. We are now putting the word adequate to compensation to further strengthen the law to protect the interest of the private property owner whose property is going to be acquired. And they are seeing the devil in this amendment. The government should be complimented for this because we are now bringing it in conformity with the Constitution. So let me recap that. The power to acquire is already there. What we are adding to it now is when you acquire and you are required to pay, you must pay promptly. And you must pay not mere compensation, but adequate compensation as determined by the Act. And there are about 3 sections that tell you how to compute the compensation. Honorable Member Figueira, are you now not clear? Have you not seen how they have misled you? So let's go to the 3rd amendment. So let's go to the 3rd amendment. By inserting the words after the word provided, the words but without prejudice to the state's right to vacant possession of the land. Let's go back now. It's a pity I don't have a screen, so we're going to put the words in as I'm reading it. But I got to do it laboriously. So let's go back again. At the expiration of 1 month from the date of the order mentioned in the last preceding section, or of any longer period fixed by the order, the land specified therein shall vest in the state, subject to the payment of the purchase price, and we put in adequate and promptly, subject to the payment of the purchase price, right? Or any compensation as provided. Now the sentence doesn't, here in the law the sentence stops. All we are adding to it is these words, but without prejudice to the state's right to vacant possession of the land. The state already owns it. All and compensation must be paid. And all we are saying that the state must have vacant possession. Now, let us be realistic. If the state owns the land, by what logic should the state not be entitled to possession? Possession is an incident of ownership. The Honorable Member Ramjatan, you will not own and not be allowed to possess. Of course, your ownership underlies an obligation to pay. So that's all we are doing, Mr. Speaker, is giving the state a power when the title is vested to take possession. And why? Why? Because if the state is going through this extraordinary measure of acquiring property, compulsorily acquiring property for the public good, then why would you detain the state from taking possession when that's the whole purpose of the exercise? Because here you can possibly have one person who doesn't accept the state's offer of compensation to hold up an entire public project.
One man could hold it up.
Well, you need help, brother. I can't help you. You need therapy. You need therapy, my friend. So, Mr. Speaker, you have to develop a country, one, the interest of one, the whole concept of eminent domain. The whole concept of eminent domain is that the power of a few must bend and bow to the glory of the collective. That is what eminent domain means. That is what it means. I didn't invent it. That is why people like you will never ever see government again. Never ever see government again. Never see government again. Because you don't have the mentality that it requires to develop. You don't see. Mr. Speaker, let me pause here to say that when we did the Borbis Bridge, we had to acquire dozens of property at the Edward Village without any controversy whatsoever. When we did the Hope Canal, the lawyer was Moses Nagamotu, acting for this government. Moses Nagamotu. When we did the Hope Canal, we had to acquire dozens of private property. We just completed the acquisition of 50 odd properties along the East Bank for the Borbis River Bridge. For the pipeline from Nouvelle Saunders at Crane from the seawall all the way to Viva La Force on the west bank of the Demerara River. Almost 10 miles beyond Wales Estate, we have acquired over 100 properties without a single controversy. One action we have in court, filed by Mr. Steve Surujbali. When we did the Crane to Schoonard Road, we had to acquire dozens of properties. And these are just months ago, and not a singular accusation of wrongdoing. Nobody has come forward to accuse the government of appropriating their property without paying valuable consideration. None, not a single one. I've given you right now hundreds of examples, live examples. 3 or 4 persons in the Demerara Harbour Bridge, all coincidentally represented, well, let me not go that road. But they had one valuation officer whose valuation they were relying on. And anybody in this parliament can guess who that valuation officer is. He produced a valuation that is 4 times the value of every other valuation officer that the government relied on, and the court. The court itself ordered valuation, and the court valuation came in line with what the government was offering. And that particular valuation officer was 400% higher than everybody else. 400% higher than anybody else. Always pissing about the place. So, Mr. Speaker, so that is what this bill does. And in our engagement yesterday, to their compliment, to their credit, the team with whom we met, and I mentioned their names, I managed to persuade them that Section 7 should be left without amendment. And I want to congratulate them for that position. Of course, they made proposals which we addressed elsewhere. So I want to put on the record, as of yesterday, the opposition team, and this was not a team, sir, that was speaking without the authority of the leader of the opposition, because the leader of the opposition also called me on the phone and spoke about the meeting. So they were there with the authority of the leader of the opposition. And when we finished Section 7.1 of the amendments, we were all at ad idem on Section 7.1. Concerns were raised and they were addressed in the other part of the bill. But the need for the state to get immediate possession was accepted as part of the general law. And Mr. Speaker, let me show you what the position is in the rest of the Caribbean, because I got it here. In Trinidad, in Belize, you have the position where even before title is vested, even before the title is vested, you have the state having a power to go onto the land. That is the position in Trinidad. That is the position in Jamaica. That is the position in Belize. I can't find it. I'm trying to get it right here now, but let me see. If I don't get it in my reply, depending upon what is being said, I will deal with that. But Guyana stood out. Guyana stood out in that ambiguous provision that seemed to suggest that compensation must be paid. And that is what we are correcting here today. That compensation must be paid before possession is given. And that position, compensation is going to be paid. Obviously, it's going to be paid. You can't acquire property without payment of compensation. But the state's business must go ahead, and the parties always have a recourse for compensation. In none of the cases that have been filed, anyone has ever challenged the state's power to acquire over the last 3 years. Nobody, even in the Demerara Harbor Bridge matters. Nobody questioning the utility of the bridge. Nobody disputing that it's a public project. Nobody disputing that their interest should not subserve to the public good. All the issue was compensation was not what they expected. And it's only 5 or 6 persons. And they have a right in law to contest that. We are not saying don't contest that at all. And that is why in the Act itself, you have about 4 sections that tell you what you must take into account in arriving at market value. Because that is what, in essence, the compensation is. It is what a willing buyer will pay, what a willing buyer will sell for, and what a willing purchaser will pay for the land at equal arm's length in a normal situation. That is how you calculate market value. So, Mr. Speaker, let me go to the amendments, which the other part of the amendment. So, as I said,
Before you go to that, you'll need an extension, Honorable AG.
Thank you very much, Mr. Speaker. I'd like to ask that the honourable member be given additional time to conclude his presentation in accordance with the standing orders.
In accordance with the standing orders, you are allowed a further 15 minutes.
thank you very much, sir. That should be adequate. So, sir, in the current law, if the state and the private property owner cannot agree on the compensation, the current law obviously allows for the matter to go to court for a resolution, and that's set out expressly. In the meanwhile, the current law allows the Minister of Public Works to issue to the property owner an advance payment, but not in cash, in the form of a bond up to 80% for that person to hold. That is the current law. We are changing that to remove a bond and to allow the minister to pay to the property owner 80% of what the government is offering as the purchase price or as adequate compensation, but in cash. How that can be wrong? We are removing a sterile bond, a bond that the people can't use, which they have got to hold on to until the matter is determined in the court. Here we are removing that, and we are putting in the hand of the private owner 80% of what the state is offering for the land. How can that be bad? At what level can that be bad? Instead of a bond that they don't know what to do with it, we are giving them 80% cash. That, Mr. Speaker, was objected to at yesterday's meeting. And no, I'm going to get to what that formulation and what was suggested, which we accepted, Mr. Speaker. What was suggested is that the minister retains the power to pay the 80%, but it was suggested that the minister must not pay directly to the owner or to the person who presents himself as the authorized or interested person. The minister must lodge it with the registrar of the court, and the person entitled must then go to the court and show to the court that he or she is a duly qualified person to receive the money and get the payment. So they have added more expenditure to the person in their effort, I suppose, to defend the persons. They have added a layer of expenditure because now the minister can't hand over the money anymore. And the concern raised was valid. And let me be fair. The concern is, as I gather it, that the minister may not be able to determine who to pay in the event of a property dispute. Now, Mr. Speaker, that is a valid concern, but that will happen in the odd case. 90% or more of the time, the authorized property owner will present himself. But in the spirit of compromise, and I don't have a problem, I want to shield the minister to ensure that the minister is acting properly. So the minister will make an application to a judge ex parte and lodge the money with the registrar of the Supreme Court, and those who feel that they are entitled to the money must go to the court, show that they are qualified to receive the money, and the court will pay them. And of course, the minister must do it as soon as the property is vested in the state. And that was there in any event, except that the person aggrieved had to write the minister for the payment. That was found objectionable. So we removed that and put an obligation on the minister. As soon as the order is vested, lodge the money with the court. We have no problem with parting possession with the money that we feel the people are entitled to anyhow. So whether we give them in their hand, or we put it in a bank, or we put it in the bosom of the registrar, that doesn't alter the principle. The principle is that we are paying what we consider to be market value, and we are giving access to the property owner with great immediacy, cash money that they can use, up to 80%. And that is the essence of what we agreed to yesterday. The other aspects of the amendment remained unaltered. But for neatness, we just removed 24A in its entirety, did the new additions, and the remainder is left as we are proposing in our original amendment. That is to say that if there is a mortgage on the land, the state acquires the land, we have to ensure that we protect the mortgagee's interest. So if the bank has a mortgage, we have to pay off the mortgage and then take possession. You can't defeat third party's interest. That is provided for, and that will allow the property to be released in the hands of the state, free from encumbrance and or, well, the mortgage, which would be the registered encumbrance in this case. And also, sir, if the property is the subject of a trust or any type of settlement, then we have to pay the people who are the beneficiaries of that arrangement. That is expressly provided for here as well. But I suppose, like the other persons, they will have to go to the court as well, because the money is going to be deposited in the court. There is another last amendment which we have added which did not feature in the discussion yesterday, but have addressed an issue that I believe the Honorable Mahipal raised. And Mr. Mahipal did some research, and I have to credit him with that. And he wanted us to establish some tribunal within the law to assess compensation. Mr. Ford and I were able to persuade him that to do that, you have to bring a whole host of new amendments, because that tribunal itself has to be like a court of law, because you're assessing the value of people's property. It means that those who constitute the tribunal will have to be particularly qualified to deal with proprietary interest. They have to have a regime of protection like judges before they can make such decisions. They must be independent, etc. To do that in an amendment of this type is beyond its scope. So, as a substitute, what I have done is to remove an archaic section from the principal law that says that the company clauses and powers consolidated ordinance 1846 shall apply. Remove that, because apparently this is a very old, it doesn't exist anymore. But there was a tribunal established apparently where you can go and settle disputes. I am substituting the Arbitration Act of 2024, which we passed. So the parties, the state and the property owner, invoking the provisions of that Arbitration Act, can appoint an arbitrator if they don't wish to go to the court and resolve their matter through arbitration, resolve the difference. The only difference that there will be, Mr. Speaker, will be the difference in quantum. And that's okay. No time you will find 100% agreements. Our experience has shown that we have had over 95% agreements in these cases. Because the state has not only used the state's government valuation officer, we hired private valuation officers. And the court and the people hired, the property owner had a right to hire their own valuation officers. And the court itself ordered a different valuation from a different valuation officer. So at any given time, you have about 4 valuation officers. And then the Act itself, Section 18, Section 17, and Section 16, guide the court on how to calculate the compensation. For example, you are not to take into account any potential increase in value because of the impending project. You can't call a high price because a bridge going there, so that you can get an additional compensation. And these principles are there as they are in every other country. But in Guyana, I don't know why we have this proclivity to invoke and evoke a controversy when one doesn't exist and there is no basis for one to exist. Ramjatan seeing Leninism and Marxism in this bill. And this is a capitalist creation. It's a complete capitalist creation. But he's seen Marxism and Leninism. But that's what the people of Guyana, those are burdens that the people of Guyana will have to bear, unfortunately. Fortunately, after next election, we don't have the likes of Ramjatan in the House. But, so Mr. Speaker, I will rest at this point in time, and I ask that the bill be read a second time. Thank you very much, Mr. Speaker.
Excellent. Excellent. Thank you very much, Honorable Attorney General. And now for the Honorable Member, Mr. Mahipal.
Sentuar. Thank you very much, Mr. Speaker. Mr. Speaker, I rise to make my contribution on the acquisition of lands for public purposes amendment bill 2024, bill number 16 of 2024, sir. And I believe it is fitting for me to clear the air on how the Attorney General and Minister of Legal Affairs represented our meeting yesterday. Let me start by saying, sir, that before the letter was dispatched for a meeting with the Attorney General and Minister of Legal Affairs reference this bill, there were conversations via telephone between the Leader of the Opposition, the Honorable Aubrey Norton, and myself, reference this very bill, and our position from then was and still is for this bill to be sent to a special select committee. That was always our position. And at the very beginning of our meeting yesterday, as Honorable Roysdale Ford will recall, Honorable Annette Ferguson will recall, and as Honorable Vincent Henry would recall, and Honorable Sherrod Duncan would recall, that position was again reiterated, and it was dismissed in totality. On the basis of dismissing that request, which we believe, sir, would have served a greater purpose in terms of addressing the act that currently exists, which is the Acquisition of Lands for Public Purposes Act, Chapter 6205, which was amended in 1972, which was amended in 1975, which was amended in 1990, and amended again in 2001. We want an act that can address what really is happening in Guyana currently. And sir, we believe strongly that this bill is a reactionary bill that has suddenly attracted government's attention because of what is unfolding with the new Demerara River Bridge. And sir, we have made the argument that instead of us being reactionary based on a situation, why not let us look at this bill in a greater context, because Guyana is moving in a different direction right now because of oil resources. And any government, whether it be the PPPC government right now or in 2025 our government, we will have to go down the road of massive development for our country. And therefore, the acquisition of lands for public purposes is an important and perhaps the most important piece of legislation that should be addressed holistically and not in isolation because of a certain situation. So that is the basis, and it remains the major concern of the parliamentary opposition. And we believe that if the bill is sent to a special select committee and we are able to address the act in its entirety, we will be able to have a more modernized bill to speak to Guyana currently. So the niceness and the hanky-dory and the pleasantries that the learned Attorney General stood and sought to decorate as though it was an agreement in totality, I wish to clarify, sir, that after not getting that main concern,
We then moved in the direction of seeking to see if we can get the Attorney General to agree with some changes to the amendment that he has right now before this House. And in so doing, there are certain parts that he did not mention also. And when he sought to say that he had to define prompt, it was me who said to him, why can't we define prompt in this bill to give it a specified timeline? Not that I don't understand that prompt means immediately, but I wanted, sir, a specific timeline so that that could have given greater assurance to know that, okay, in 2 days I'm going to get the money. In 3 days, I'm going to get the money. In 5 days, I'm going to get the money. That is what I wanted. Because we know that prompt could very well mean instantaneously, but me ain't get me $100,000 yet. So that is why, sir, it is important for timeline and boundaries to be set. That is the direction I was going with. Secondly, sir, there was another part of the bill that spoke to shall not exceed 80%. And when we saw the words shall not exceed 80%, that allows for it to be 70%, 60%, 10%, or even 5%. And in so doing, sir, it was recommended by Honorable Roysdale Ford, let it be 80%. Not exceeding, it has to be 80%. And that was also accepted by the learned Attorney General and Minister of Legal Affairs. Sir, there were more arguments that were put to the learned Attorney General and Minister of Legal Affairs, where Honorable Roysdale Ford will be able to elaborate greater on, because I do not possess to be a lawyer by any way, shape, or form. But I do have common sense, sir. And I did say to the Lord Attorney General that the tribunal to which we are speaking about is that tribunal to determine the compensation, the adequate compensation, not necessarily to replace the entire court system. Because if somebody feels aggrieved, they must still have at their disposal the remedy of the court. They must still have that competent jurisdiction in which they can appeal and seek greater remedy if the tribunal doesn't present it the way they wanted it to be. And I did point out, sir, that there are several countries that have used tribunals to determine the adequate compensation, such as Trinidad and Tobago, such as Jamaica, Barbados, St. Lucia, St. Vincent and the Grenadines, Dominica, Antigua and Barbuda, the United Kingdom, Canada, Australia, New Zealand, India, South Africa, Singapore, and Malaysia. These are all countries that are using tribunals to get it done correctly in the best interest of their citizens. And I still feel strongly that if we are to address the Acquisition of Lands for Public Purposes Act and make it more modern for today's society, we can consider a tribunal having examined all of these legislations that are currently in place. Sir, I want to also say to you that our central, and you see, before I go there, sir, the tribunal is all about addressing the matter in an adequate and in a timely manner so that it can become it can be dealt with quicker. We know how the court system works. We know that there's certain language. We know there's certain boundaries. There's certain do's and don'ts. A tribunal will be more flexible. And it may even give way for people who cannot afford a lawyer to appear themselves and make a case that is greater than what can be done before a judge with a lawyer present. He who feels it knows it. So if somebody that is feeling a pain, that is aggrieved by this compulsory acquisition, may not have the resources to take a lawyer and so on, but they can appear before a tribunal and be given an opportunity to plead their case, then that can also be considered in modern Guyana. So our central and fundamental position remains that this bill should be sent to a special select committee for a more holistic and comprehensive examination. This approach is essential to modernize the existing Acquisition of Lands for Public Purposes Act, Chapter 6205, which has become outdated in light of Guyana's evolving socio-economic landscape. As the country embarks on a path of unprecedented growth, largely driven by the wealth generated by the oil sector, we are poised to engage in significant public infrastructure projects that will require land acquisition for public purposes. Given these developments, it is crucial that our legal framework be updated to meet the challenges of a rapidly changing nation. The current Acquisition of Lands for Public Purposes Act remains inadequate to address the complexities of land acquisition in today's context. The existing provisions, while functional in a bygone era, fail to reassure citizens that their land, often their most prized possession, will be treated with the fairness, respect, and transparency it deserves. The process of compulsory land acquisition, when necessary, must ensure that the rights of citizens are upheld and that they feel adequately compensated for their losses. As it stands, the Act is insufficient to provide this level of confidence, particularly when it comes to compensating citizens for their land. In this regard, we point to Section 19 of the existing Act, which states, in determining claims for compensation, the court shall have power to consider and award to the claimant, in respect of compensation for compulsory purchase, in addition to the matters herein specified, any sum not exceeding such percent of the market value of the land at the time of awarding compensation to the court seeming fit, unquote. While this provision provides some flexibility to the courts in determining compensation, it is inadequate in reflecting the true value of the land to the citizen. The compensation process under the current framework is too narrowly focused on the market value of the land at the time of acquisition. It fails to account for the broader, more personal factors that give land its real worth to the individual. Factors such as social, sentimental, cultural, and emotional value. Land is not just a physical asset. It is often a vital part of a person's identity, their livelihood, and their family's legacy. The value of land cannot and should not be reduced to a mere financial transaction. In a modernized act, compensation should account not only for the physical market value of land, but also for its social and sentimental worth. These are intangible aspects that deeply impact the lives of citizens. For instance, sir, cultural significance. Many people's land holds cultural value, often being tied to ancestral history or religious practices. Losing such land cannot be compensated for by money alone. Emotional attachment. Land is often tied to personal memories, family traditions, and milestones. It may represent a home, a place of growth, or a family's hard work and aspirations. The emotional connection cannot be measured purely in financial terms. Livelihood and economic dependency. For many Guyanese, land is a critical source of livelihood, whether as farmland, small businesses, or other productive uses. The loss of such land has significant socio-economic consequences for the individual and the wider community. Intergenerational legacy. Many lands have been passed down through generations, symbolizing family legacy and continuity. This intergenerational aspect of land ownership must be recognized in any compensation framework. Social connectivity. Land forms the foundation for community cohesion, contributing to social ties and collective well-being. Displacing people from their land affects not only them, but also the wider community's social fabric. And sir, in many cases, land also carries environmental significance. Preserving local biodiversity or supporting ecological systems important to the community. This value extends far beyond market consideration. Sir, and it is in that context that I repeat the call for us to examine the acquisition of lands for public purposes, Bill 2024, in a special select committee. Given the complexities and the profound implications of land acquisition on citizens' rights, we strongly believe that a piecemeal approach to amending the law will not suffice. The current amendments proposed are helpful in addressing isolated issues, and that is why Honorable Roysdale Ford, myself, Honorable Sherrod Duncan, Honorable Annette Ferguson, and Honorable Vincent Henry went along in examining what is it that these honorable members on the other side with their one-seat majority was going to shove down our throats with or without any participation. And we know, sir, that it was after that meeting with Ipadaji that was aired publicly, and it was brought to the public's attention that an engagement was sought via writing about a week ago with no response. We hurriedly got a response, I think it was Tuesday morning, yesterday morning, and we ended up meeting at 3 o'clock the afternoon. We could have, sir, we could have stayed away because of the untimely invitation, I would call it. We could have said that, okay, you don't want it to go to a special select committee, we ain't participating no more. We could have been, in a manner, basically say to them, no, it's either our way or no way. But we know how they stay, sir, how those honorable members over there are. They will oftentimes show us with that one seat that they could do it their way. So we took the mature position to the higher ground. Yes, we took the higher ground, sir, and we went into the discussion to see how best we could have altered and made proper representation on what they had. And today we have this amendment before you to amend what they have in the existing bill before us. But, sir, the essence of this piecemeal fix to this important piece of act that exists, it does not take a holistic approach to modernizing the entire framework. And that is where we have our problem. A thorough review of the law is necessary to ensure that it adequately reflects the needs of a modern, developing nation like Guyana. The referral of this bill to a special select committee would allow for a comprehensive, inclusive process. It would enable public consultations, expert input, and input from all relevant stakeholders, ensuring that the final legislation addresses not only the technical aspects of land acquisition, but also the concerns of the citizenry, civil society, and even the private sector. This inclusive approach is essential to building trust and ensuring that the final law is fair and balanced. Moreover, this process would allow for the incorporation of social and sentimental values into the legislation, which is critical for the government to demonstrate a commitment to the welfare of its citizens. Politically, this approach would signal to the people of Guyana that the government is not simply interested in facilitating economic growth at any cost, but is deeply committed to protecting citizens' rights and welfare. As the country continues to grow, it is vital that we foster a sense of national unity, trust, and security for our citizens. A transparent, inclusive, and comprehensive review of the acquisition of lands for public purposes law will ensure that citizens feel secure in the knowledge that they will be treated fairly and justly in the event that their land is acquired for public purposes. The essence of our argument, sir, and our position on the opposition side is that though we may be in government with the power, we must always consider our citizens. We must understand that we were given this power to be servants of the people, and that they must not be our servants. And every act, every action that we sit in this National Assembly and take, it must be one where we are confident that the people out there feel safe and secure and not run away with the perception, as in this case, that they are not being considered. But, sir, I thought that we would have had that understanding of moving to a special select committee so that we can hammer out a piece of legislation that can reflect modern Guyana, and we could have stood together and say we did it for Guyana. Unfortunately, our friends on the other side did not see it fit for us to modernize this legislation. They did not see it fit for us to address this legislation in a more holistic manner. They did not see that it is necessary for us to ensure all our people are considered when it comes to the acquisition of lands. Whether you are the Amerindians, whether you are the Africans, whether you are the East Indians, the Chinese, the Portuguese, whatever ethnicity, we have to ensure we give that proper representation. And sir, I want to leave by saying to you that after elections 2025, when we take government, we will modernize this piece of legislation for the benefit of all of Guyana. I thank you, sir.
Thank you very much, Honorable Member. Honorable members, I think this is a good time to take the suspension. It is now 12:08, and please listen out for the two bells. The first bell we will ring at 5 minutes to 1. The second bell at 5 minutes after 1. And I'll be sitting here at 1:05 waiting for a quorum. Thank you.
We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one karage, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree.